Hello, how are you today? This is Bong Soo-jung, Korean labor attorney. Today, I'd like to introduce two labor cases related to the hair shop. So one case is the hairdresser who worked for a particular hair shop for 2 years. Then when she resigned, then she asked for the payment of severance pay. Then employer rejected to pay because she worked as a freelancer or the service provider. The hair shop paid based on the number of the customers that she provided for hair hair management. So she received 25% of all the cost or the price she earned. So she received as a commission, not the salary. So but the employee stated she was exclusive hairdresser working for this the hair shop. Also her work is regulated. Also she could not live during the working hours. Also whenever she take a time off or day off, she must receive special permission from the employer. But as a representing employer, I explained what she earned is a portion of maybe 25% of wholesale she made for the hair shop. Also, after completing her work, she could work for other hair shops. So she was kind of like a contractor who provide the special service. So labor inspector agreed that she's not employee, but she is a service provider. So company should not pay severance pay. So that is a good conclusion. But in the court ruling, there is an opposite cases when hairdresser provide the labor service, even though they receive the commission, but they are controlled very strictly by the employer, and they have to work. Also, they are not allowed to work for other hair shops. Also, they could not be replaced by the other the hairdresser when they are absent. So in that case, the court ruled such a hairdresser is employee, not the freelancer. Okay, that is the first case. The second case is intern, like probationary workers working for hair shop. So what they do is they learn how to the manager hair, also some support the hairdresser for cleaning hair of customers. So then what they receive is just 1 million won. Then they worked for 10 hours per day for 5 days. So their wages should be like 2 million won. But what they earn is just 1 million won. So labor inspector, while they have auditing, they pointed out about this violation of minimum wage. So then work like employer explained that they are trainee who are learning rather than employee or workers who provide labor service in return for earning money. But the labor inspector reviewed their work. It is partly they are learning how to manage, how to become a hairdresser. So, but main duty for the intern workers are to provide labor service, like to take care of customers' hair, also supporting hairdresser. So such a intern who learn skills at the same time provide labor service. We in Korean labor law we regarded them as a worker, probation worker. Then they are entitled to protection of all labor union act. Then so basically the minimum wage. So they are entitled to minimum wage. So when labor inspector calculated the all wage, the total based on minimum wage plus their total hours, then it was about 2 million won. So company had to pay additional 1 million won each month, retroactive for total years they provide as intern. So okay, this case was solved well, but employee learned a harsh lesson, something about not following labor standard act. Okay, thank you for watching. Bye bye.